nobody likes discovery. So it's like basically instead of doing the discovery process, just do the actual trial.
So actually the fun stuff.
Yeah, exactly. And only the fun stuff.
Oh, that's a good segue. Hi, welcome to another episode, a special episode of the Avocado Toast. And as you can see, we're not doing breakfast today. We're in the evening because we're here with Nick Barthel from Barthel Legal, and he had a couple motions to get through today, so we're having beers instead.
Yeah, cheers.
How you doing?
I'm good. Busy, which is good. It's always better to be busy than bored, so enjoying that.
What have you been busy with?
It's like a lot of the cases that I've pushed, I seem to have filed a bunch at the same time, so a lot of discovery motions are just piling up on each other at the same time. So basically this week I had 3 discovery motions, and then I also have maybe like 5 or 6 other cases where I just have a lot of discovery that I've received that I need to go through. So it's just kind of like discovery on discovery on discovery, and then a couple other cases I need to file. So
all right. Well, before we get too into the detail, we should provide a little bit of context.
Yeah.
So Nick is down here in San Diego. He's, not my words, by many people, many experts I've met recently. Nick is a Wiz Kid in the EFTA, Electronic Fund Transfer Act. And Nick and his firm helps consumers in the consumer finance arena. Here, Nick, can you tell us a little bit more about what you do?
Yeah, so we've a practice, consumer protection's the general umbrella, but what we like to focus our time on is cases where someone's a victim of identity theft or some kind of financial scam. So our goal is basically to get consumers' money back from financial institutions and to get their life back on track in general. But, you know, we take other cases in other realms too, but that's kind of where we seem to find the most joy in helping people is within the realm of identity theft or victims of financial crimes. So
financial crimes. Can you give us some more concrete examples? Like what kind of crimes and what kind of issues do you see?
Yeah, so we see kind of, they're all over the map. Most of them are cyber crimes. So that may be a fraudster getting remote access to a device and stealing funds that way. It could also be someone's credit card or debit card being sold on the dark web, and then whoever buys those, that fraudster then charging goods and services or whatever on those cards. And ultimately the consumer, what they typically do is dispute with the financial institutions to get their money back or to get out from under debts that were fraudulently opened or charged on their legitimate cards. And if the financial institution does not release them or does not provide those funds back to the consumer, then what we do is we basically step in and we try to get the consumer that money back. Basically force the financial institution to do what they're required to do by law, but they're refusing to do for whatever reason.
I see.
Yeah.
Okay. So correct me if I'm wrong, but to summarize, well, our practice do intersect. Your practice, a consumer protection attorney, helps consumers when they've been damaged in the financial arena and they've had money stolen from them or taken from them in one way or the other, and you help them recover those funds when the institutions, such as the banks and such as the credit bureaus, are unwilling to help them. Would you say that's correct?
Yeah, and another big part of it too is in like the global world that we live in with the internet, most of these fraudsters are abroad, and not only that, but they're also untraceable most times, where you wouldn't even be able to find them if you wanted to. So it's almost like the only way for the consumer to get their money back is from the financial institution itself. So that's kind of like the focus, is trying to get these people to get their lives back to normal as possible, and trying to find or navigate kind of the big knot of issues that they have to try and untangle that and get their life back to the way it was before when all this happened.
Yeah.
So that's kind of our focus.
I see. Yeah, and sometimes when I talk to people about work, they sometimes say, "Oh, why should the bank be responsible, or why should these financial institutions be responsible?" And it always befuddles me because I'm like, "Oh wait, are you feeling bad for the banks?" Right? Like they are required by law to have processes and procedures to protect the consumer because they're banks,
Yeah.
right? You don't expect the average person to step in to protect the general public against money laundering, right? Against funding genocide. You expect institutions with trillions of dollars under management and the resources to do so to take these steps, right?
Yeah.
And sometimes people forget that these are the bad guys. Wells Fargo is a convicted felon, right? Wells Fargo has pled guilty to multiple felonies on defrauding their own customers, right? And I'm just using that as one example. Would you agree with that?
Yeah, and I mean, the thing about it too is, at the end of the day, as you said, financial institutions are really the only ones that can stop this from happening. So any of us, Joe, consumers, we're not going to see the patterns of the type of fraud, but the financial institution will. And so we see this a lot with wire transfers. So right now, the law is very thin on basically forcing financial institutions to help consumers get their money back when it's stolen via wire transfer. So because of that, amazingly, most fraud is left through accounts via wire transfers. The reason why? Because financial institutions don't have any incentive to fix the issues surrounding the wire transfers because they know most people aren't going to sue them for it because most attorneys won't take it. And then the small percentage of attorneys that will take it, the damages could just be limited to the refund of what was taken from the wire transfer. So without consumer protection laws that basically say that a bank would have to pay a consumer not only whatever's stolen, but also their damages on top of it, when the banks are looking down the barrel of a law like that, they're a lot more likely to design their systems so that those kind of errors don't happen in the first place. It would be a much worse world that we live in if these laws did not exist, because the banks would not have any incentive to protect consumers.
Yeah.
Because without attorneys like us basically forcing them to pay out, they would have no incentive to design a secure system.
And I mean, that's not conjecture, right? We have real life examples of systems that don't have these kind of laws and protections for the consumer, right? I mean, these are your, no offense against any of these countries, but your Mexico's, your Russia, right? Your, China, right? Or I mean, really any country that's not America or some other Commonwealth countries.
Yeah.
Right. It's, I'm a Chinese immigrant, and when I was explaining these kind of laws to my parents, and they were shocked because in the world they grew up in, it's like if somebody does this to you, you're just out of luck.
Yeah. Yeah, and I mean that's kind of what's nice about consumer protections. It's designed to be a safety net for people that are defrauded. And I think when Congress or the California legislature enacted a lot of these laws, a lot of the purpose was deterrence. It was a way where they saw an issue in the world and they were like, this is how we're going to fix it. And they also provided attorney's fees, so people don't have to pay anything out of pocket to get represented by attorneys like us, even if it's a case only over $10 or even $1 or even a cent, because Congress wanted to make sure that if someone is a victim of identity theft, or they're a victim from their credit card being charged or their debit card being charged, no matter what the amount was stolen, that person should have a right to an attorney. And so they knew if they had the banks paying for our attorney's fees, if we prevail, then attorneys would be willing to help people no matter what was stolen. And so that's a really important thing for these kinds of laws too.
So you're saying the consumer, they don't need to pay the lawyers out of their own pockets?
Nope. At Barthel Legal, we don't charge a single cent to
Really?
any of our clients. we cover the costs. We don't charge them anything, and then it's a scenario where if we're able to get them a recovery, then that's how we get paid. And if we're not, if we lose the case for whatever reason, we will never go after them for the costs or anything like that. We just take the hit and then we move on to the next case.
Okay. And
yeah.
You seem to be doing well, so that.
Yeah, I mean, and it's great for the consumers because it's basically they have like no risk, right? Because it's like, what do you have to lose to have us represent you?
Yeah, either you get salvation or you just stay where you are.
Yeah, exactly.
That's good. So Nick, how did you get into this world?
So it's kind of funny. I mean, I always knew I wanted to help people with my law degree.
Better than hurting people. You know?
Yeah. Originally, I started doing surrogacy contracts for like, I worked for a firm that did it for a lot of like celebrities. But unfortunately, after I was done interning, they weren't hiring at the time, so I kind of just took whatever job was available.
Wait, what do you mean? What do you mean surrogacy contracts?
So it's kind of like when you have a woman carry another woman's baby. If let's say she's infertile, has some kind of medical complications, or just doesn't want to carry the baby, then they hire a second woman to carry the baby for her.
Like Phoebe from Friends.
Yeah, I don't watch Friends, but for sure. Probably, I think I might have heard of that.
Okay.
So we did that I did that for a little while, and then I was basically just looking for a job. I passed the bar and was just like, okay, I need some kind of income coming in the door. And I had a friend that was working for a consumer protection firm, and they happened to be hiring. So I just said, sure, why not? Jumped on it and just basically fell in love with it day one. Started doing class action stuff only. And after a few years, started my own gig, Barthel Legal, and wanted to help more individual cases and litigate all the way through to trial for people that have, gone through the worst experience of their entire life. And so that's kind of how I got into it, was really by accident. But once I was in it, I just fell in love with it. Yeah,
that's a lot of attorneys I talk to. They mention there's almost always a serendipitous manner in how they fall into their lifelong. What's the word I'm looking for? I want to say passion, but it's almost more than that.
Career.
Yeah, it's different, right? Because you work for yourself. So if you hate it, you wouldn't keep doing it.
Yeah.
Right. Which I don't know if you can say that about a lot of people in their jobs. Right?
Yeah.
I feel like most people. My girlfriend asked me the other day what my favorite day is of the week, and I took a second. I thought about it, and I said Monday. Right.
That's psychotic.
Yeah, it's weird, right? Like it's weird.
Yeah.
But I mean, I pretty much work 7 days a week, so it's not like, Monday is a different day, right? And honestly, I kind of take it a little easy on Mondays because I can really focus on Sundays and Saturdays because the calls are not coming in as much. And around my home and around my office, it's less busy, so like it's just is easier, it's more tranquil environment. But yeah, what you said is 100% correct. Like if you stumble onto this and you end up enjoying what you do. Now, so you're saying that you started out doing class work and now you do single plaintiff work?
For the most part. I mean, every once in a while I'll do a class action if I see something. Like, for example, we have a class action right now against a debt collector because they purchased a bunch of payday loans. So these loans have interest rates that are just insane. Like my client's interest rate was 130%.
100, like
130%, 130%.
So if he borrowed $10, what would he have to pay back?
If he borrowed $10, I think he would have, I'm not great with math, but something around like his interest on that $10 would be $13.
And he has to pay back the original, right?
Yeah. So like actually it'd probably be more than $13. It'd be $13 and change probably. So
That's loan sharking.
yeah, it's loan exactly. And so I had it was actually a debt defense case. The client came to the door to have me defend him.
So you do debt defense also?
Yeah, a little bit. Every once in a while I'll take a case. And this guy came to my door basically saying that he needs someone to defend his debt collection case. And so I looked at it and I was like, whoa, you have 130% interest rate on this? And he was like, yeah. He's like, I had moved from the East Coast to San Diego at the time. I didn't have a job. And so I needed a loan to basically survive. And I had really bad credit. So he's like, the only people that would give me a loan were these loan sharks. Mm-hmm. And they said I had to pay 130%. So that's all that's all I could get as a loan. So I did it because it was the difference between whether he would be on the streets or have a place to live. Mm-hmm. So I looked at this case and I was like, well, this looks like a class action because I'm sure they have a whole portfolio of other debts, similar people. So we did it. We got all the class information. Well, it turns out we looked at the whole portfolio. I think the lowest interest rate was somewhere around like 75%, which is still like 3 times basically what the average credit card would be. And then
which is like 20%.
Yeah.
Yeah.
And then on the high end, I think the highest I saw was like 350%.
What?
So basically it's like take what you borrow and multiply it by 3 every single year. So basically creating a hole that you can never dig yourself out of.
Yeah.
And so we brought the class action. We're litigating it right now, and that's the only class case I have. So I do class actions still every once in a while if I think there's something that warrants it. Basically, our goal is to wipe out everyone that has these loans. We're going to force the debt collector to wipe them all out. So all these people would have this big chain that's on their back removed. Which would be huge. So that's kind of what we're aiming for, is to, at the minimum, get everyone their debts wiped, because none of these loans should have been open in the first place. They're just not conscionable contracts. No one would ever sign that if you weren't in a situation like my client, which is sign the contract, get the money, or you live on the street. So
yeah. Well, so what laws are there to protect people like your client?
Yeah, so California enacted a law recently saying that loans like that are capped around like 30%. Mm-hmm. So you can't go beyond that anymore. Mm-hmm. Back in the day when...
And what do you mean by recently?
Probably in the last like 2 years.
Okay.
So very recent. Before that, it was kind of wild, wild west. But at the end of the day, there's still contract law, which is... If a contract, especially between a corporation and a consumer, that's also a contract of what's called adhesion, which is basically the corporation drafts the contract and then you either take it or leave it basis. There's no negotiating the terms.
Unequal bargaining power.
Exactly. And so under contract law, in that kind of situation, the terms of the contract have to be what's called conscionable, which is basically fair or even like doable. So having someone borrow money for 130% interest or 300% interest, that's not a fair deal. That's basically the corporation just taking advantage of you. So under contract law, that's just not a viable legal contract, and so it can get voided. And so that's basically what we're seeking.
Great.
Yeah.
I feel like the government should be doing this.
Yeah, well... Not enough government money, I guess. They'll let us do it.
Okay. All right. Now, what would you say is the difference between doing class actions and single plaintiff work? And as a follow-up to that, what do you love and hate the most about each of those things?
So class actions are great because you can change a lot of people's lives and make a lot of people's lives better. So in the case of, a payday lender, we have a class of, I think it's hundreds, I think we might be over 1,000 people in California that are going to have loans with crazy interest rates, like hundreds of interest basically just get wiped and removed from their credit scores too, or their credit reports.
So you can make real change.
Yeah, so it's like so many people in California will get this benefit. So being able to do that is such a blessing. The downside of it is it's going to take years of litigation. We've already been litigating this class action for 3 years. And it's defendants, anytime we bring a class action, they pull basically any defense that they can possibly think of, because the longer they can delay, the better. So that's the downside of class actions, is it's kind of like you fight over smaller petty things because any argument that can be made will be made. For individual cases, same thing. I mean, it's nice because it's so intimate. An individual will come to you on most likely the worst day of their entire life. And they usually feel like no one's heard them, like no one is helping them. They feel isolated in the world, because usually the banks are telling them to go pound sand, or even are saying, we think that you participated in the scam, which is probably the worst thing you could tell a victim of identity theft or fraud.
Blaming the victim.
Yes, exactly. And so by the time they get to your door, they're so heartbroken. And so for you just to even listen to them and to hear their story and believe it is it's such a relief for them just to have that. And then throughout the litigation process, working with a single individual to help them understand their own story and to build it, and for them to realize that they're actually the hero in the story, not the victim. And then to put that on for a trial or to a jury or an arbitrator or a judge, where you finally get to really put the power back in the person's hands for the first time in the last year or so. That feeling of giving that person that power back is something that you just can't get from a class action as much. And that's really the reason why I do this work and why I push my clients' cases as far as they'll let me push them, especially to a jury, because it's a jury of their peers, not the bank's peers, really. And
well, so, what are the bank's peers?
Yeah. They're not sitting in the jury box.
Yeah.
So whenever you bring a case to a jury, the jury just is going to side with your client and understand your client as long as you put on the story, the right way. And so that kind of building the story and putting it on and giving my client the power back that they never had or that they had lost is really what I think I love the most about individual cases.
You get to actually meet the person you're helping and help the person that you're meeting. Yeah,
and they almost become like family by the end of it, because like you're living their story as much as they're living it, and it's very intimate because you get to know them so well and their family and what their struggles and their trials and tribulations are, and so you really get to know a person like you do your own family members, really.
Okay. Now, yeah, that makes total sense. And before I became an attorney, I didn't realize how personal it would be. I come from 4 generations of doctors, and I thought being an attorney, you're just you're dealing with companies, you're dealing with institutions. I didn't realize that before I started how much you're able to help people, and you really could, because you can make a huge difference in these people's lives. And and what you said about being powerless is so true. Like, well, here, why don't you explain? Like, why would a consumer come and find you, a consumer protection attorney, instead of going through this battle themselves?
Well, first of all, I've done this battle about 1 million times, and they would be approaching it the first time, so they wouldn't know how to do it. And that's what I always try to tell people is, I know the way I tell my clients how to dispute. I tell them, put everything in that letter that proves that you're a victim of identity theft or fraud or whatever the circumstances are. which can be kind of hard because, like, how do you prove a negative that you didn't open an account or that you didn't make those charges? So because I've been doing this so long, I know how to kind of like show that, I guess. So, like, for example, were you somewhere else at the time it was made? Is there a way that you can show that that's not within your spending pattern? Or is there a way that you can show, charges are made in Georgia, but you live in San Diego and you were in San Diego? Do you have like photos in your photo reel, stuff like that? So those are ideas that most people wouldn't think about. The other thing, even taking a step behind that, is if you have one account opened in your name, you probably have a couple other accounts. So helping someone understand where you can go to get a credit report, what that credit report would show and how to read it. Where do you look? Like, for example, in the inquiry section of your credit report, that's going to show if other loans are applied in your name but maybe not granted. Or there might be other accounts currently open that you need to reach out to those people and close them too. So it's kind of helping people through the process of how do you dispute and how do you dispute well enough that, ideally, best case scenario, the account will be closed and you're released from the debt. But worst case scenario, well, now you've created a really good lawsuit because you've given them all the proof that they should have known that you did not open this account or you did not make these charges. And then now I step in and, force them to do the right thing.
I see.
Yeah.
So to summarize, you hire a consumer protection attorney to fight your battle for you because of your expertise. You've done this a million times. You know how to avoid the pitfalls, and you know how to present a case well, right? And that bleeds into the idea of being a zealous advocate, right? Is advocacy. And then you can put forward this story. And the third point is that you can achieve results, again, because you've done it a million times. And also to bring it back to what you said earlier, you don't charge anything up front. So
yeah. And then point 4, it's like, what do you got to lose?
I mean, I wish I can get somebody to do everything like that for me. Yeah, that's really cool. That's really exciting. And you're not lying. You really do take it to the end. Because Nick doesn't like to talk about this much, but he just very recently had a major win.
Yep.
Can you tell us a little bit about that? Like, what was the case and what
So we had a case. It was a wire case, which are kind of tricky cases because the consumer protection laws don't.
Pardon the interruption. What is a wire case?
Oh yeah, sorry. So that's where money's stolen via wire transfer versus like if it was Zelle or if it was stolen through like a debit card charge, thing like that. Those are easier cases to litigate because Congress has enacted laws specifically in consumer protection for those. But wire cases are, for whatever reason, excluded from those laws, so they kind of float out in this abyss where there's some laws that apply to them, but they're not really consumer-friendly laws. So we took a case. It was an elderly individual who had $70,000 stolen from her via wire transfer.
Wow.
Yeah, very life-shattering event. It wasn't just $70,000 too. It was $70,000 because that was all that was in her checking account. So basically, she had her checking account wiped down to zero.
They took everything.
Luckily, she had a nest egg, a retirement that she could kind of survive off of. But that created even more stress because she didn't plan on tapping into that until a couple of years later. So she went to the bank, explained the scenario. The bank denied her claim because they said that an OTP, a one-time passcode, had been sent out and verified, and so it must have been her.
That's when you get the notification on your phone on the text message saying
like a little, like the weird numbers where there are only like I think like 6 numbers or whatever, 5 numbers. Well, we brought suit, and in the process of litigation, we got phone recordings, which we had to fight tooth and nail to get because the bank didn't want to give those up. Once we got those phone recordings, it became very obvious that there was a fraudster with a very different voice than our clients. Like if you were on a spectrum, she was like on this side of the spectrum for a female voice, and the fraudster was on this side of the spectrum.
Okay.
To be honest, the fraudster kind of sounded like potentially could have been a male pretending to be a female. Like they were just like clearly not the same voice.
Uh-huh.
And it turns out that when the first wire transfer tried to go through, it was flagged as being potentially fraud. An investigator for the bank looked at it, determined that it was actually fraud, and then froze the whole account. Now, from our position, what the bank should have had or should have done was have our client go into a branch in person, verify herself through, photo identification or something in-person process, and then they would unfreeze the account that way. Unfortunately, that's not what they did. They let the fraudster call in again, unfreeze the account based on the same information that was used to send the wire in the first place, such as the OTP.
Mm-hmm.
And then from there, they let the $40,000 wire go, and then 2 subsequent wire transfers too.
Wow.
For a total of $70,000. So we brought suit against the bank. They fought tooth and nail. They said our client was part of the scam. Wasn't until the actual day of arbitration where we were in trial that they had changed their tune and said, it's tragic what happened. We wish this didn't happen to her, but there's no legal remedy. We deflated that argument pretty quickly, and the arbitrator ruled in our client's favor, awarded her $150,000 in emotional distress, the $70,000 that was stolen, interest and other taxes and fees on top of that for another, I think it was like $30,000. And then they brought down the hammer against the bank and awarded, I think it was $400,000 in punitive damages because, as the arbitrator said, the bank had treated her so coldly and had treated her with such indifference from the very start. And then because she was elderly, added another $90,000 because in California you can multiply anything that's awarded for a punitive cause, like fees or punitive damages. If you're involved with an elderly or a veteran, you can multiply it. So then the arbitrator multiplied it for a total of $1.55 million.
Wow. So what was the total judgment?
To be determined. So we're seeking our attorney's fees on top. So it's the award to her is $1.55 million, and then attorney's fees might increase it to 1.7, 1.8, maybe even 1.9, depending on what the judge awards.
Wow. So you guys brought justice down and was able to get almost $2 million on behalf of the client.
Yep. And throughout the entire process, they were just not willing to work with her or acknowledge her as a victim. And so it made a pretty easy decision to go to trial because there wasn't really another option. But we enjoy trial, and so we're happy we got to do it, and we're even happier by the result.
Incredible.
Yeah.
Incredible. Wow, that's crazy. I mean, the client must have been thrilled.
Yeah. She broke down crying. She said, finally, I feel like I can live my life again. Because for the year and a half that we were litigating, she literally was pinching every penny.
Mm-hmm.
She would go to the store and buy those Marie Callender frozen chicken pot pies,
Mm-hmm.
She was like, I buy those because I could eat, they're so cheap and I could eat it for dinner and maybe even stretch it 2 meals. Like she went basically forced into poverty because of this.
Wow.
She was really scraping by, and it affected her relationship with her grandkids, and it was a horrible scenario. And so she was very relieved to be now in a position where she can see that she basically is going to survive the rest of her life and that she's going to have a retirement. Because it was looking for a second there that she might not even have a retirement. She might have to keep working the rest of her life.
Yeah.
So,
Yeah, because I hear from defense attorneys all the time, oh, what are the damages? What are the damages, in these consumer finance cases? And it's exactly what you're saying. These are real people we're dealing with, right? And oftentimes these are vulnerable groups like the elderly, like veterans who fought for our country. And after they've been damaged and defrauded, they have to forego the ability to eat, to pay rent, to give gifts to their grandchildren, right? To see their family at moments of celebration, right? I mean, these are real damages on real people, and it's easy to sit in your, I guess, glass throne, right? 44 is above the rest of the commoners, but to not treat people like a human being is plainly wrong.
Yeah, and the thing too with a lot of like defense bar is they'll say, what's the damages here? Like I have a case right now where it's a 19-year-old kid who fell victim to a scam, and the fraudsters went in his account, opened up a $9,800 loan in his name, and the bank knew from the very start. The very first person that investigated was like, oh, this is an account takeover. Fraudsters opened this loan. But they continued to pursue him for the debt anyways. And so now we're in trial, and they're saying, well, what's the harm? I mean, it's only a $9,800 debt. And it's like, well, yeah, sure, to, this big bank, it's only $9,800. To my client, who's a 19-year-old kid already working 2 jobs just to scrape by, owing somebody $9,800 is stressful as hell. And the proof is in the pudding. I mean, the guy went to therapy, he's having panic attacks. Like, this is no BS. I'm not just making this up. Like, this is his life, and this is how he's experiencing it. But for the defense bar, they don't ever have to speak to my client, minus a depo. So they don't hear the person on the other side of the phone that calls you and is freaking out and is panicked and has no idea what to do next and is going through all these very intense emotions. And so they don't really see that, and so they always are kind of like, well, what's the harm? Oh, it's emotional distress. Like, what's the most there? Like 20,000? Like, how much could that really be worth? And there's kind of this like view that they weren't hurt that bad. Like, oh, it couldn't have been that bad. But they're kind of coming from a position where it's like, well, you're not speaking to the person, so you don't actually see and hear them. So,
yeah. I heard a great saying from a personal injury trial attorney once, and he says, he asked, well, defense attorneys are always saying, oh, this is minor surgery. This is minor surgery. And then I asked, what is minor surgery? And the real answer is minor surgery is surgery that somebody else gets.
Yeah.
Because when you're having surgery, it's never minor.
Yeah.
Right, and with the clients we deal with is, oh, what kind of emotional distress are they facing? What kind of damages are they facing? It's like, well, I promise you, if it happens to you, you will see it real quick, and it does. Yeah, and it does. I have people that I've litigated against call me when they go through these kind of issues, and they're like, oh wow, I can't believe this is happening.
Yeah, the other thing too, on the plaintiff side, other plaintiffs' attorneys oftentimes will, if they have a client with some kind of prior emotional distress, like let's say they're bipolar or they have anxiety and they had it before this incident occurred. Sometimes plaintiffs' attorneys will think, oh, well, that kind of kills the emotional distress damages because they already had some kind of underlying issue. But the thing is like, it's a simple question. Did this make your anxiety worse? Well, the answer is almost always yes. It made it severely worse, and it was actually, oftentimes I'll hear clients say, my emotional distress damages, well, they don't say it like that, but they're like,
they're not as articulate as you are.
Yeah, they're like, yeah, but they say basically that like having some corporation reach their hand into your life and jerk you around without your control is so much worse and on a different level of stress than all of our everyday stress that we all experience, like taking the kids to school or going to work or, juggling all these tens of thousands of things that we do throughout the year while trying to just live your life on top of that. All of us have that, and that's always stressful. But then when you have this hand from a corporation come in and jerk you around, that's a stress that's just different. It feels different, and it feels worse. And that's the thing that a lot of clients constantly talk about. They're like, yeah, I had anxiety, but this made my anxiety so much worse. And it was a different kind of anxiety, and it has a different kind of stress. So that's something for like a lot of plaintiff's attorneys that they should think about, is like, just because your client had some prior anxiety or prior stresses, that doesn't mean that the stress they're feeling from this is less or doesn't matter at all. If anything, it might kind of prove it more because you have something to compare it to. Yeah,
absolutely. Emotionally heavy stuff aside, what's the funniest encounter you've ever, like the most humorous encounter you've had since you've been practicing and representing clients?
I had a case where it was this old guy who said he was a victim of fraud, and I was trying to trace back the charges, so I looked at his statement, and there was this like weird website that I had never heard of, so I was like, what is that? And it had a bunch of charges on it, and I looked it up, and it was like this weird like fetish website that was like run out of like Eastern Europe. And I was like, what the heck is this? And so that was an interesting experience. And then when I was kind of like, hey, do you know anything about this website? He was like, oh, yeah, like, I heard about that, but I thought that was a dating site. It's like nothing weird. And I was like, I don't think it's something weird. So that was kind of an interesting experience.
Yeah, it's funny to see, take a peek into people's everyday lives and what they're really into. I'm still new at this, right? I was on the defense bar until just less than half a year ago, right? I'm really glad to be back on the plaintiff side, helping everyday clients, helping everyday people. But you've been doing this for a long time. You've been flying your own flag and acting as an attorney and also as an entrepreneur. What are some key takeaways you've had as an entrepreneur in running a law practice? Because not every lawyer does this, right? This is a special, unique skill.
Yeah. I would say one of the key things is, one, to build your systems. So you want to make sure that you have some kind of process for doing everything. I think one of the biggest takeaways for attorneys would be to not be the jack of all trades. Pick the thing you like the most and only do that, and keep it narrow. That's probably the most important thing to running a successful law practice. Don't try and do every law.
That seems counterintuitive. Wouldn't you be able to get more clients if you were to do everything?
Yeah, you get more clients, but you would spend most of your time trying to figure out how to litigate that kind of case. So if you do just the same kind of case and only just that kind, sure, in the beginning, if it's your first time doing it, it's going to take you a little while to figure out how to do it. But once you figure it out, then you got it. And then once you got it, then you're going to get better at it. And then once you get better at it, then you're going to know exactly the value of it. So then when a case walks in the door, you know exactly what that case is going to be worth. You know exactly how much time you're going to have to do or put into it. So it makes your life a lot more predictable, and which is a lot easier to plan and grow from there. Yeah, and probably to focus most of your energy on the higher yielding cases too. That's also a good important point.
I see. What's the best part of being your own boss, and what's the worst part of being your own boss?
Best part is being able to pick my schedule. Worst part is I have to pick my own schedule. So I'm going to work more, if not more, than I would ever work for somebody else. So just kind of that, there's no safety net. It's not like I'm working for a big corporation where I can just, someone else will pick up the slack. It's like, no, you're kind of all it there is. So it's like you're working a lot harder that way. Plus, you're wearing multiple hats. That also kind of sucks.
What's your favorite hat?
Lawyer hat.
Okay.
Yeah.
So you like to be the lawyer?
Yeah. Yeah.
Okay.
Makes me miss the days where you could just be a lawyer and that was all you had to be.
Okay.
So
what's your least favorite hat?
Probably just like admin in general, dealing with the stupid BS that you have to deal with.
As a business owner, there's so many things that, I mean, I feel like people have tried to warn me, but I still just don't know. Right? You don't know it until you're doing it.
Yeah.
Right? I mean, you expect things like dealing with taxes or, filing documents. I was like, hey, I'm a lawyer. I can do this, right? But it's the things that come at you that are surprising, that you don't expect, that you never even knew existed, right? For me, like I would just dealing with different vendors, right? Dealing with different people trying to sell me things. They will call me nonstop, and they are very creative. And then I have to deal with surprising things going wrong, right? Like the phone lines going down, right? And then you have to figure out how to solve that problem, right? And you have to worry about how to pick out the best group health insurance.
Well, I have a question for you. So, do you enjoy doing the SEO and advertising portion of it, like figuring out where the clients are and how to get them?
I do enjoy that. I like to think of myself as a problem solver, right? And whether that's in litigation or that's in running business, nothing makes me happier than solving a problem and reaching a good solution. And with marketing and SEO, it's a completely new arena for me to learn because I just didn't know. Now I'm very blessed. I have friends and connections in my network that can help me, right? I mean, I'm sure as hell bugged the shit out of them, but they help me. And when I'm able to solve these problems that I've never seen before, I really do enjoy it. And you're able to see results very quickly, right? Because in litigation, you think you solve a problem, you might not see resolution for years.
Yeah, or you just closed one door just to open 4 more.
Exactly. Yeah. But in business development and marketing, once you figure something out, you see results almost right away. And I really, really enjoy that. But I also feel it's a personality thing. I think it's a personality thing. I love developing systems. I love watching things grow. And at the end of the day, this is my baby, right? Earlier when you said that as a business owner, the best part is managing your own schedule. The worst part is managing your own schedule. I agree 100%, but when it's your own life's work, it doesn't feel so bad.
Yeah, totally.
Right? Like I don't mind working sometimes later in the night or laying awake in the middle of the night thinking of a solution to a client's case because I'm bought in.
Yeah.
It's as much as my client's case as it is my case. Whereas back when I used to represent these banks and these major corporations, to be honest, I was rooting for you.
Yeah. I honestly think that's pretty normal. A lot of the cases I have, it's very rare that I get a defense counsel that's kind of like bought into the defense mentality. Most of them are like, yeah, like my client messed up here, and they're kind of like they want our client to win. Usually they think I'm a crazy person with the numbers I'm throwing out, but in general they understand that my client's been wronged and that there should be some kind of resolution in their favor. It's just kind of like, I guess, the value. But yeah,
there's a certain congeniality within our profession, right? It's not as contentious as some people make it out to be. Certainly not as you see on TV. Is a lot more relaxed than you would think. Now, when millions of dollars at stake,
Yeah.
the tension can certainly get a little bit higher.
And I mean, there's certain attorneys out there too that their style is just to be a complete dick.
Yeah, I don't get that.
Yeah, and you run into them every once in a while, and you're just kind of like, this is our job. Why are we making it harder than it needs to be?
Mm-hmm.
Or really, why are you making it harder than it needs to be? Because, fighting amongst friends is a lot easier than fighting against someone that you hate, because then there's just emotions involved and it gets more complicated.
Yeah. Yeah, and we met each other actually because we were opposing counsels.
Yep.
Right, and Nick caught me when I was. He caught me by surprise one day. He called me, and then we were trying to figure out a problem in one of our cases, and we just had a great banter. And he just seemed like a very nice guy to work against. And then after our case resolved, we ended up grabbing a beer with each other. And we talked, and now we're, I would say friends.
Yeah.
Right? And, but some guys, they come at you. I've had opposing counsels writing letters to my boss.
Really?
Yeah, this one guy, he wrote a letter to like a formal letterhead letter to my boss about how bad of a job I was doing. And
that's wild.
Yeah, and
what kind of case was that?
It was I was representing a bank. I was representing a lender, and he was co-counsel. This isn't even opposing counsel. This is co-counsel. He was so unhappy with my work, he wrote a formal letter to tell on me, and the entire dispute was about a decision that our client made.
Yeah.
And we had a meeting, and the client was like, I don't understand what his issue is. Like, you just did what we told you to do. And I was like, yeah, should I tell him to fuck off, or should you tell him to fuck off?
Yeah. What a dick. That's wild.
Yeah, and I don't really see how that benefits him in the long run, because you always end up working with the people that you're going against.
That's the one thing I don't have is the defense side experience. It's interesting because I always wonder in these cases where we have, 3 credit bureaus and then a furnisher like a bank or credit card company. Mm-hmm. On top of it, so you have 4 defendants that are all on the same side, but they're also pointing the finger at each other, saying, well, it was the furnisher's fault. That's why we, didn't fix the credit reporting, or vice versa.
It's like the Spider-Man meme.
Yeah, exactly.
Yeah.
And it's funny because they're all doing that on that side, and I always wonder how much communication's happening. I can tell when there is, because I'll get these motions for summary judgment where each defendant files a different motion. Where to oppose each one, I have to take a slightly different stance. So they're basically forcing me to speak out of both sides of my mouth. Mm-hmm. So those cases are interesting, but I've never had the defense side of it where you have a weird co-counsel kind of relationship because both your clients are getting sued by the same person.
Yeah, it's. I think it's when egos get into play.
Mm-hmm. Yeah, totally.
Right. Ego's a funny thing. At the end of the day, you can't buy dinner with the ego, right? You can't buy golf clubs. You can't go on ski trips based on ego.
Yeah.
Right? And I just think people should relax a little bit. Now, can you go into more detail, Nick, about when you say these co-defendants, right? So when you bring a action on behalf of your client, you mentioned furnishers and the bureaus. How does that work?
Yeah, so the way our credit reporting system works is, let's say I'm the consumer and I have a credit card. What happens day to day, me paying that credit card, then let's say the credit card company is Capital One. They track what I do on that credit card, whether I make payments or not. And then if I don't make a payment,
they're the furnisher.
Yeah, they're what's called the furnisher because they furnish information up to the credit bureaus, Equifax, Experian, TransUnion. There's a handful of other ones too, so that's why they're called the furnishers, because they furnish the information to the credit reporting agency. And they actually pay for Experian, Equifax, or TransUnion to host that information. So what a lot of people don't know is that's how the furnishers actually make their or the bureaus make their money. So when you have an issue, like let's say an account's opened in my name, but it's not me, they have the furnisher who's saying, hey, Nick opened this account, and let's say it's maybe charged off or 30, 60 days late. Hey, Nick opened this account, one, and two, he's also delinquent on it. We had to charge it off. So they're now paying for Experian, Equifax, and TransUnion to report to the world, hey, Nick had an account with Equifax, and he was delinquent on it, and they even had to charge it off. They had to sell it because they couldn't even collect the debt. That's how bad Nick is. So when we dispute with the bureaus and the furnisher. And the bureaus usually take a dispute and they bring it over to the furnisher and say, hey, Nick's saying this account's not his. What's the deal with this? And then Capital One or whatever furniture company, they're supposed to look into it, and then they report back to the bureaus, delete it. It's not him. It's identity theft. Or they'll say, it's verified. Keep reporting it as is. So when you bring suit, then the bureaus throw the furnisher under the bus, and they say, well, if we just did what the furnisher told us to, what were we supposed to do?
I see.
Yeah.
So the consumer credit world is this intricate web of furnishers and the credit bureaus, where the furnishers provide information on the consumer and the credit bureau maintains the information on the consumer. And when the consumer is damaged, as the consumer protection attorney, you have to figure out who did what and how the consumer was damaged by these companies, and they point the finger at each other.
Yep.
I see.
Yeah. There's a law called the Fair Credit Reporting Act, which basically says that at each layer, whether you're Equifax, Experian, or TransUnion, or whether you're Capital One, each one needs to do a reasonable investigation. And what determines a reasonable investigation is what's in that dispute that your client gives to them.
I see.
Yeah. And so at each layer, they're required to do their own due diligence. They're not supposed to point the finger. Each one's responsible for whatever they're doing.
Because they're all supposed to be there to protect the consumer.
Exactly. Yeah.
Yeah, they don't do that.
Yeah.
Now, is there the FCRA? That's a federal law, right?
Yep.
Is there any specific California protections?
Yeah, so there's a California law. It's almost in a lot of ways better. It's different, but almost better. So in California, we have a law. It's called the California Credit Reporting Agencies Act.
CCRAA.
Yep. Yeah, exactly. And what that law says is it only applies to furnishers. And it says that if a furnisher is furnishing information to a credit reporting agency, they need to make sure that that's accurate. And if they knew or should have known of an inaccuracy, including something that's maybe accurate but misleading, then they should not be reporting that information to those credit bureaus. And the consumer that's harmed by that can seek statutory damages and actual damages and attorney's fees against that furnisher.
I see. What's the difference between statutory damages and actual damages?
Yeah, so statutory damages are they're kind of punitive in nature. So it's like no matter what your actual damages are, you get this on top. So it's a kind of a per se award. So in the California, the CCRAA, it can be up to $5,000 per violation. So courts have read that to mean if, let's say, this same furnisher sends the inaccurate information to three different credit bureaus for 5 months, that's 15 separate violations.
Oh, wow.
3 bureaus, 5 times, it's 15. And then so it could be up to $5,000, times 15, basically.
$75,000 in statutory damages.
Yeah.
Wow. So it's an extra damage that by law is granted to the consumer for each violation that does not matter what the facts say happened to you. If
Exactly.
they made a mistake, then to punish them, to punish the wrongdoers or the bureaus or the furnishers in this situation, the consumer is owed up to $75,000 in this situation.
Yeah, exactly. And it's punitive, so it's to punish them, and then to get that, you just have to prove that they were basically violating the law and just didn't care about you or others.
That's probably not hard to do against banks.
No, it's really not. It's surprisingly easy.
All right. Okay. Fair enough. Now, let's see. So that's the CCRAA and then the FCRA. Now, and you mentioned statutory damages. So earlier, Nick, you mentioned that these things appear on a person's credit report. Okay. I oftentimes hear people talk about the credit score. There's a lot of confusion in this arena. What is a credit report and where do you get a credit report?
Yeah, so a credit report it's kind of like your, what you get in grade school, your report card.
Mm-hmm.
But instead of it being, social studies, math, whatever, it's your debts that you owe. So it could be your rental, whoever your rental company is, what you owe them in rent. Could be your credit cards, could be your mortgage, could be your car payment. And basically they give you a ranking of, A to F if you're making your payments on time. So if the second it's late, they'll report it as late, and then that'll affect you. It'll go onto your credit report, and then that'll affect your credit score. And if you get below a certain credit score, then it may be hard to get credit or access to rental properties or basically anything in life. Credit's king. It's anything you want to get, they're going to check your credit.
Yeah, I forgot what he said exactly, but I think Jay-Z said the most important thing is credit. Don't die on the street that your mom is renting on.
Mm-hmm.
Right. Okay. Well, thank you so much for being with us, Nick.
Yeah.
This has been a pleasure.
Yeah, I've enjoyed it.
Yeah, thank you so much. You've been tired. You've had 2 motions to get through this week.
3, actually.
3. Well, that's a lot of moving.
Yeah.
Thank you so much. And until the next time, we will talk again on another episode of the Abogado Toast.
Thank you. Good chatting with you.
Good chatting.